Committee on Judiciary, our 5th meeting of the session this year. Sorry for the delay. I know we're getting into the part of session where we've got committee meetings happening and people are running from room to room. So trying to accommodate schedules and sorry for the late start, but we had VMAP running a little long next door. Mr. Secretary, please call the roll.
Senator Berg. Senator Carroll.
Here.
Senator Deneen. Senator Neal. Senator Schickel. Senator Stivers. Senator Storm. Senator Turner. Vice Chair Wheeler. Chair Westerfield.
Here. Seeing that we have a quorum and we're authorized to do business, we're going to jump right in. But we are, members always put the bills in numerical order. And Senate bills first, House members, just in terms of how they show up on the agenda. But we're not going to go in that order today. I'm trying to accommodate some witness schedules. So first, we're going to take up House Bill 159, an act relating to immunity from criminal liability for healthcare providers, sponsored by our friend, Representative Flannery. And we have our other friend, former Senator Julie Denton, at the table with him. You have the floor. And Senator Wheeler, wasn't expecting that one. Y'all jump right in. You have the floor. Members or folks presenting, bear in mind we've got about 50 minutes left, and we need to get through all these bills. So whatever you're going to say, try to trim it. Go ahead.
Thank you, Mr. Chairman. I'll try to remember the 5 B's of communication. Be brief, brother. Be brief. Patrick Flannery, House District 96, presenting House Bill 159 today. This is an act that has the huge support of our nurses in this state, and it involves criminal liability of healthcare providers. Very simply, what this bill does, it codifies the common law. It seeks to be proactive, protect, and prevent. In a handful of states, we have witnessed scenarios where healthcare providers, they are negligent. Maybe they just make a simple error or medical mistake, and then the lines of criminal and civil law are being blurred, and they're being criminally charged. So this seeks to protect the frontline healthcare workers, such as our nurses and our physicians and others that may be working in primary care or hospitals. It prevents the unjust prosecution of these healthcare providers when a medical error that qualifies as basic common law negligence is made, and prevents the blurring of those lines, as I stated before. I'll be happy to answer any questions.
Got a motion from Senator Schickel and a second from what sounded like Senator Deneen. Yeah, Senator Carroll.
Thank you, Mr. Chairman. Just a quick question. In some of these other states, when cases similar to this are being charged criminally, what approach are prosecutors taking to get around the intent in this, wantonly, recklessly, whatever? How are they getting around that to get to a criminal charge?
That's a great question. I know that charges have been brought. The, I guess, most famous example is, I believe, at Vanderbilt. That's commonly cited. I think they're just trying to find whatever facts they can to bring those. I do want to be very clear that if there's any sort of civil standard more than negligence, so something that might be wanton or willful, or something that might go towards something to show what we would call in the law a mens rea, an intent, that would not qualify under this bill. We have not seen examples like this in Kentucky, but we are seeing more examples of this. Obviously, sometimes when medical errors are made, when there is negligence, death can occur, serious physical injury can occur. So you can have a lot of pressure from the decedent's family or loved ones to maybe bring criminal charges. And ultimately, I don't feel like that's probably good for healthcare, because we want these mistakes to be reported. And if you have a medical provider that feels like they're not only going to be potentially civilly liable, but also criminally liable, that really chills their desire to be sure that the system is working efficiently. So that's one of the reasons we feel like this bill needs to be brought.
Thank you. Thank you, Mr. Chairman.
Any other questions, members? Seeing none, we have a motion and a second on the bill. Mr. Secretary, please call the roll.
Senator Berg.
Yes.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal, Senator Schickel, Senator Stivers, Senator Storm,
No.
Senator Turner, Senator Wheeler,
Aye.
Chair Westerfield.
Aye. Bill passes with favorable expression on a 7-1 vote. I think that's right. Is that right? 8-1? 8-1. Thank you, Representative. I appreciate it. All right. Now to Senate Bill 153, sponsored by our own Senator Johnny Turner, and an act relating to jurors. Let's turn the volume down. Turn the volume down. I appreciate the passion and the enthusiasm. All right. Senator, you have the floor.
Thank you, Mr. Chairman. Senator Johnny Turner from the 29th District. Senate Bill 153 is for those people that are 70 years and older, giving them the free choice to elect to be excused for service from the term which they're directed to serve or permanently. It's kind of unfair to make elderly go in these courthouses, and even the judicial centers don't have place for coffee, water, candy bars. They got hard seats. The only people who get the soft seats are the actual jurors that's serving on the jury, and they can be in there for hours. They get $12.50, and I was told by a Senate colleague that the price of parking in their district was $18. But there is no reason for us not to consider that 70-year-olds should have the right to be relieved from serving. There's a form, Mr. Chairman and members, that is pages long that you have to fill out. This bill eliminates having to answer questions whether you're a citizen or under 18 or resident and all that. You get to go strictly by filling out your name, your address, going down to through the form, and it says, I am 70 years of age or older, and you can check one. I wish to be excused for this term of jury service, or I do not wish to be excused from the term of service. And you can then say that I want to be excused permanently. So the form creates a place for you to determine whether you want to stay on or be excused. And the exception of
Is that a motion? Got a motion from Senator Berg, a second from Senator Wheeler. I don't want to cut you off, but I want to ask if there are any questions. Yes, Senator Schickel.
Thank you, Mr. Chairman. I'm going to be voting no, but I won't explain my vote when I vote. But I just think it's important to realize, and I certainly, with great trepidation, I vote against the bill of my friend here. But a couple things. First of all, it's important to remember that the demographic of our society is tilting older. This bill would apply to me. So it would apply to me and probably many people in this room. But I've noticed, and my judges tell me, they have trouble finding people now for jury trials. I appreciate the spirit of the bill, and I like the way it's drafted, but the fact of the matter is many folks my age have time now to serve on juries. The other factor is that the right in American jurisprudence to have a trial by jury of your peers, if you have an older person who is on trial, and that limits the pool of a jury of your peers. And you can now petition the court to be excused from jury duty, and it is a bit of. I know that it is a bit of a inconvenience for people, but I have not been contacted by any folks my age pressing for this. So that's just a couple of things that I wanted to share with the committee. And of
That's a
course,
great vote explanation, Senator.
Thank you. Thank you for your indulgence.
Yes, sir. I do want to. Did you have a question you wanted to ask? All right. Any other questions? Seeing none, we have a motion and a second. Mr. Secretary, call the roll, please.
Senator Berg,
explain my I vote?
Briefly, yes, ma'am.
You wore me down. No, I agree with Senator Schickel that we need people in the jury. And I agree that it is crazy that we're paying jurors $12 or something cents a day. In Louisville, it's literally costing people more to park. But you're right. I mean, for certain people, if you're going to be excused, you don't have to fill out the form over and over and over again if you have a good excuse. So thank you, sir. Aye.
Senator Carroll.
Vote no and explain. Yes. Wise words from Senator Schickel. I completely agree.
Senator Deneen. Senator Neal. Senator Schickel.
A very respectful no to the bill sponsor.
Senator Stivers. Senator Storm.
Explain my yes vote.
Yes.
Last session, I think we had a bill that
We did.
was before this body, and I voted no for the exact reasons that my colleague voted no today. But this bill only addresses the permanent issue of exclusion because last year's bill passed, correct? So I vote yes.
Senator Turner.
Aye.
Senator Wheeler. Chair Westerfield.
Aye. Bill passes with favorable expression on a vote of 7-2. Thank you, Senator.
Thank you, Mr. Chairman and members of the committee.
Senate Bill 202, an act relating to conditions of supervision. There is a committee substitute that belongs to your chairman that makes one small change and requires that the program you're going to hear the senator talk about be evidence-based. I'd entertain a motion to adopt that sub. There's a motion and a couple of seconds. Thank you. All those in favor of adopting the sub, please vote by saying aye. Aye. Those opposed? The sub is before us. Senator, you have the floor.
Thank you, Mr. Chairman, and thank you, panel members, Senate members. Good morning. I will let my guest introduce himself later. In fact, I'll introduce him. This is Michael Bogan. He is the director of the Group Violence Intervention Program in Louisville. Senate Bill 202 seeks to clarify that under state law, conditions of parole may require a person to participate in a specific program designed to reduce violence like group violence intervention does. It is a comprehensive partnership with local, state, and federal agencies aimed at helping young people involved with groups or gangs find a new path away from violence and crime. And this program has been successful in Louisville by reaching out to known gang members, warning them about the consequences of the crimes and helping them change their paths. And Mr. Bogan can be obviously more comprehensive about that program itself. So far this year, 51 people have participated in the program through in-home visits and regular group meetings known as call-ins. However, its impact is currently limited because in Kentucky, it cannot be mandated that a condition of parole because of a perceived uncertainty about the law. So this would clarify that. The committee substitute adds a requirement that the programs to reduce violence be evidence-based. In other words, not something out of the sky, but something that's rooted in something that's tried, tested, or studied, or research-based in some way. So. No, I know when to quit. I just finished.
Sorry. Thank you. Thanks. I'll put all that now that the mic is on. We got a motion from Senator Turner and a second from Senator Wheeler. Any questions, members? All right. Seeing none, Mr. Secretary, call the roll.
Senator Berg. Aye. Senator Carroll.
Aye.
Senator Deneen. Senator Neal.
Aye.
Senator Schickel. Senator Stivers. Senator Storm. Senator Turner. Senator Wheeler.
Aye.
Chair Westerfield.
Aye. Bill passes with unanimous support with favorable expression there on a vote of 9-0. Thank you, Senator.
Thank you very much. Thank you,
Sure.
everyone.
As amended by the sub. Thank you. All right, Senator Tishner. Thank you for your patience. Well, there you are. Thank you for your patience. This is Senate Bill 249, an act relating to sex offenders. And you have the floor, ma'am.
These chairs are always too tall. Thank you, Chairman Westerfield. This is not a very complicated bill, and I think it's a loophole that we can close to protect minors. And I focus a lot of legislation around protection of minors. This would simply define social media platforms and require someone who is on the sex offender registry for abusing a minor to use their legal name on social media platforms. This issue was brought forward to me by a constituent who was hosting an event, and someone reached out to bring his business forward and had his name concealed. And upon further research, this was an event for children. The interested participant wanted to bring his business forward and be around children, and he was on the sex offender registry. But it took a little bit of research to find out who that person was.
We've got a motion, and I'll make the second on the bill. I appreciate that. I wanted to make sure, and I think I had a conversation with you. I know I had a conversation with Mr. Corbett as well about, and with Randall, talking about it only applying during the time they're a registrant. I worry about whether or not it would be lawful if we did it beyond that. But I think while they're a registrant, and that's clearly the language of the bill, but that's a very reasonable restriction and one that I'm happy to support.
Thank you.
Is there a question? Any questions? Senator Berg, briefly. Yes, ma'am.
First of all, thank you for this bill. I think this is awesome. My question is, can we not extend this? I mean, I think our social media platforms would be so much safer if people were required to be online who they are in the world. Thank you. Thank you. This is awesome.
I think we would come up to some free speech issues, which obviously, if you're on the sex offender registry, you do lose some of those freedoms.
Yep. Any other questions? Seeing none. Got a motion and a second on the bill. Mr. Secretary, please.
Senator Berg. Aye. Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Schickel. Aye. Senator Stivers. Senator Storm. Aye. Senator Turner. Aye. Senator Wheeler.
Aye.
Chair Westerfield.
Aye. Bill passes with favorable expression on a 9-0 vote. Thank you, Senator. Okay. Representative Dietz, do you have a preference for which one we do first? All right, let's take up 155 first, if you don't mind. An act relating to the disposition of property and declaring an emergency. You have the floor, Representative. And you or your guest can introduce your guest.
Thank you, Mr. Chair and members of the committee. Stephanie Dietz from the 65th District, and I'll let my guest introduce herself.
I am Debbie Wright.
Mr. Speaker, or Mr. Chair, I will try not to talk like a lawyer today. What House Bill 155 does is, typically when you are in the middle of a divorce process, there's marital property and non-marital property. So the first part of what this does, it's going to give discretion to our judge to consider criminal misconduct against a spouse that results in a felony conviction when they divide the marital property. So that's an important part of that. It also, and it falls under KRS 532-200, or is the criminal attempt to commit murder under KRS 506.010. And if it occurs within the last 5 years of marriage prior to the filing of the petition for dissolution, or any time after the filing of the petition. And that was important because we know that victims of domestic violence sometimes take a long time to disclose. So that was important for the 5 years before and for the 1 year following, because we also know that acts of domestic violence occur after the filing of a petition. Secondly, what this does, and what my guest could speak to briefly, is that one of the biggest assets that people typically have is their retirement benefits. And this will make sure that when you're dividing your assets, what judges typically do is, it says equitable division, but they do an equal division, so it's 50-50. So if the wife already has 50% or the husband, it's going to allow that the extra 25% that would go to the other spouse that would automatically be non-marital. and then it leaves 25% to the discretion of the judge to decide. So there's the ability for 100% of the retirement benefits or the whole life insurance benefits to go to for the victim's spouse to keep, which is the case of my witness that's here today. And if you all would like to hear from her, I could let her briefly tell you her story.
Ms. Wright?
Yes. I was married 40 years, actually. We're still going through the divorce. But one day, just out of the blue, my husband was in a big van that we have, and he asked me to go around the back of the van and check a cord because it had a rooftop air and it wasn't working, he said. So I went around the back, opened the doors, and I said, well, it's not plugged in, and it's never been unplugged since it was installed. So I reached in to get it, plugged it in, the air kicked on, and about that time, I realized the van was rolling backwards on top of me. So I tried to get out of the way, and as much as I could, and the door caught me and knocked me down, cracked my head in the driveway, and my leg was sticking out, so he ran over my right foot and ankle, and as I was screaming, the van stopped, and he finally came around the front of the van, and I asked him to call 911 because at that point I wasn't sure what was going on. So he took my purse from me and my phone and took it into the kennel building and brings out a pillow, and then he says they're on the way, which was a lie. And then he got back in the van. He said he was going to move it away from me. So he pulls the van back up to the building, and I'm laying there in the driveway, and all of a sudden I look, and the van is rolling backwards towards me again. So I didn't know if I could walk, so I started rolling as fast and as hard as I could to get out of the way. And the van hit my back. The same tire hit my back and scraped down. And then I realized this is no accident. So then he pulled forward again, and I knew I had to get up. So I did. I got up and got behind the dumpster, and he backed it up a third time trying to hit me. And I just stood there and watched him. He pulled forward. He gets out of the van, and I'm, of course, cussing and I'm carrying on and asked him what he was trying to do, kill me, and he said, yes, I am. And so I went past him, got my phone, went in the bathroom, called 911, and 911 informed me that there was no other call from our address. So anyway, he's been charged. Yeah, he's been charged with attempted murder, assault second, and what he was trying to do, because he did not accelerate the van, he wanted it to look like an accident, and that's what he's telling. That's what.
Pension.
Yeah, and
Do you have a pension?
yes, I am a retired state employee. I worked 28 years for the Jefferson County Circuit Clerk's office, and I have I have a pension, and I have a 401k, and I just don't think that it's fair for someone who tried to kill you to be able to get half of what I'm going to live on, after the divorce.
I would completely agree with you. Got a motion from Senator Wheeler and a second from Senator Deneen. We do have a question from Senator Storm.
Actually, I have a couple.
That's fine. Yeah.
Thank you for your testimony here today. I'm a little bit confused. Are you saying that your divorce is not final?
No, it's not. I live in Trumbull County. And his trial for his criminal charges is not until January 27th, 2025.
So your divorce is not final,
No.
nor is the criminal case resolved.
No.
And you're bringing a bill today that would change the outcome of that pending litigation prospectively, correct?
Yes.
And that would impact potentially the property settlement agreement or the property settlement division that the court might order, correct?
Yes.
I'm concerned about that. Thank you.
Senator Turner.
And I got a question, I guess, for the presenter. This says within the last 5 years of the marriage, correct?
If the act occurred in the 5 years prior to the petition
So
being
an act
filed.
could occur, they could live together for 5 years, and then at divorce that time, bring this up, even though they lived as nice as a couple, man and wife. Some incident have occurred, and 5 years later, they get divorced. One of the spouses could bring it up and say, I'm going to get this because you did that 5 years ago.
Yes, and we did that because victims of domestic violence often take a long time to disclose those acts. A lot of women and sometimes men will stay in a marriage because they're scared to leave because of financial reasons or because they're afraid of what's going to happen with their children. So we picked the 5-year look back. We felt that that was fair. We didn't go all the way back to date of marriage, and then 1 year post filing of the petition.
Another question, Mr. Chairman? Yes, sir. But from a legal perspective, you put people in a position that they can't save evidence. There's no way to prove against them, just an allegation. In that position, you'd put a spouse into of just bringing something up and there'd be no history of it or anything like that they could say, well, he or she beat me and all this stuff years ago within that 5 years, and I'm entitled to file this claim. That's the way I read it.
It's not just an allegation. It would be a conviction.
Oh,
It's not just an allegation.
okay, so there had to have been a conviction, but they could go back and live together after
Yes,
the
which
conviction
happens.
and still make the claim.
Yes, which I've seen happen.
Okay. Thank you, Mr. Chairman. That's all.
Senator Carroll.
Thank you, Mr. Chairman. My question has to do with the PFO provisions related to violent offenses. And, how would that work if there was a previous violent offense that occurred 4 years earlier, but yet the most recent offense is not really one of those offenses, but a felony nonetheless that would lead to a charge of being a PFO, and that would be considered a violent offense. So I could see some confusion on how that might work if the most recent offense is it could be less than these other violent offenses. It's only a violent offense because it is another felony that leads to a PFO charge. And I'm probably not explaining that very well, but you just have to look at the PFO provision that makes a PFO becomes a violent offense just because it's a PFO, not based on the most recent offense.
If I understand your question, you're saying they've committed offense that would make them, then it would be a PFO offense within the 5 years, and that's the concern?
Yes. It says that the offender has a felony conviction for any of the above listed, which would be sodomy, assault, sexual abuse, all the others, within the 5-year period preceding the date of the latest conviction. The latest conviction would not necessarily have to be one of those offenses. It would just have to be a felony to reach the PFO, which makes that a violent offense.
I'd be happy to look at that. That was not something that was brought, that we talked about when we were doing this bill, but I'm happy to look at that.
And I am not an attorney, but I have spent a lot of time in courts over the years. But it appears that could be an issue that could cause some problems with the courts. Thank you, Mr. Chairman.
Any other questions? Have we adopted the sub? Have we had a motion and a second on the sub? Motion on the sub. Second on the sub. All those in favor of it? There is. Hold on a second. This is 155. We're not on 207.
There's no sub.
I was already going to 207, Representative. I'm sorry about that. You're freaking out thinking there's a sub?
There's a sub? I didn't know about it.
My brain's thinking about 207. Sorry. All right. Do we have a motion and a second on this bill? Thank you, Robert. Seeing no further questions. Yes, sir.
Are there any issues related to what Senator Storm brought forward that we need to consider?
I can't speak for Senator Storm. The fact that it requires a conviction doesn't guarantee that Miss Wright, whose case I wasn't familiar with before she showed up here and told her story to everybody today, doesn't guarantee she's going to get any sort of relief from this legislation. And I think that's a reasonable requirement, that there be a conviction. Obviously, you can't act on just the allegation alone. Senator Wheeler?
I would agree with you, Mr. Chairman. I think, this bill would affect far more people than just Miss Wright potentially, and
Sure.
I think so. I don't see why. And she's not the one bringing the bill either, so this is Representative Dietz.
Any other questions? Yes, ma'am. Senator Berg?
I just need this clarified. I've been divorced actually twice. And both times, each person's individual retirement accounts were kept out of the marital assets. The one went to the one and the one went to the other. It was never a discussion as far as individual retirement accounts. Other assets there were. How common is it that people share their retirement accounts? Pretty common.
Yeah, those are considered deferred earnings. They're part of the marital property. So I would say in almost nearly all of my cases, the retirement accounts are the largest asset they have besides maybe the equity in their home. So that happens a lot.
All right. Mr. Secretary, please call the roll on this bill not amended by any substitute.
Senator Berg.
Aye.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Schickel. Senator Stivers. Senator Storm.
I've learned an important lesson. May I explain my vote?
Of course.
I've learned an important lesson here today, and that's number one, don't ever commit to voting yes until you hear the testimony of the witness, no matter what the bill says, because based upon the testimony that I've heard today, I'm extremely I'm struggling with this decision. I'm going to vote yes today because I've committed to that. But my concern is that the divorce is not final. We have a witness here testifying the divorce is not final. Charges are pending, and we are getting involved in the middle of pending litigation as a General Assembly, and I don't believe that's appropriate to do. This could impact the property settlement agreement, according to the witness's testimony, and although it's not the witness's bill, that's concerning for me that we are crafting legislation that could favor one party or another in pending litigation, and I don't think that's appropriate. But I did tell you that I would vote yes, and I'm going to stick to that word, but I want to reserve the right to change my vote at a later date. Thank you.
Senator Turner. Senator Wheeler.
Yes.
Chair Westerfield.
Aye. Bill passes with favorable expression, 7-2. Thank you, Representative.
Thank you.
Now we have House Bill 207, which does have a sub, but before we do it, and I didn't talk to Representative about this, so give me some latitude here, Representative Dietz. This bill is important, but I think it's important, and this is my opportunity to try to educate this committee, because you guys aren't as big a nerd as me, on the danger posed by computer-generated content. Now, this bill's about deep fakes and about child sex dolls too, and it's important. But the deep fakes and the AI-generated content that this bill addresses, I think it's worth talking about. Now, a year ago, I mean, we all know what ChatGPT is. I've got it on my phone. I use it to produce text stuff from time to time just for fun and to be silly. I did use it to create a bill short title. I won't tell you which bill it is to come up with an acronym. But there are now models that are being talked about to create video content. We've seen photo content created by artificial intelligence systems that are really entertaining and fun and great, but I think it's important for you to appreciate the risk. Just 2 weeks ago, OpenAI, which is the platform or the company that develops ChatGPT, released in a very limited way a new product called Sora. And it's video content, AI-generated video content based on a text prompt. And you can find this online. This is their little introductory video. There's no sound, but this shows you the beginning here, and it's going to show you the prompt of text and then the video. Now, y'all, some of these are so good they'd fool everybody in this room. You can know that you're looking at completely fake content but it would fool people. It's why Senator Mays Bledsoe's bill about electioneering AI-related content last week was so important, Senate Bill 131. I've got a bill that I just filed 317 a day or two ago on performing artists and protecting their name, their likeness, and their image. But there's a criminal element to the use of these sorts of platforms and devices too, and that it's dangerous. And so I wanted to just demonstrate this. If you wouldn't mind, Robert, hitting play for a couple of minutes here. This one is nuts. And wow. Thanks, YouTube. What has the LRC account been pulling up? Look, but see that again, none of this is real. None of this is real. And the clips that show an actual human are the terrifying ones. That man doesn't exist. That scene doesn't exist. Thank you. So I wanted to show that to show what these systems are capable of today. And when this sort of software gets democratized, as it certainly will, and becomes available on every smartphone anywhere and on bad actors' computers everywhere, the risk of what can be done is incredibly dangerous or incredibly great and pretty terrifying for children in particular. I'm going to let Representative Dietz talk about the bill. I do want to say that the substitute keeps the substance of the bill entirely there, but makes two really big changes. It adds a more comprehensive definition of computer. It changes digitization to computer-generated image or computer-modified image, computer-generated image. And then I want to thank Randall for catching that one of the sections or statutes for possession of the material wasn't included in the original bill, and none of us managed to notice that, but he did, and so now it does. So with that, I make a motion on the sub. There's a second from Senator Wheeler, I think I heard first. All those in favor of adopting the sub, please vote by saying aye. Aye. Those opposed? Representative Dietz. Hope you don't mind I took the liberty of showing some of that there at the beginning, but you have the floor.
No, thank you. Stephanie Dietz, State Representative from the 65th District. I'll let my guests introduce themselves, but thank you for the word change because the word digitization was very hard to say on the floor, so I do appreciate that change. So I'll let my witnesses introduce themselves.
My name is Jeremy Merle. I'm the Deputy Commissioner for Counter-Exploitation for the Attorney General's Office.
Mike Bowling, Lieutenant with the State Police, Commander of Electronic Crime and the Internet Crimes Against Children Task Force.
Thank you, Mr. Chair and members of the committee. I believe that Chair Westerfield actually brought this bill in the past several years that probably predates my being here. This is a piece of legislation that will give our law enforcement the tools they need to protect our children from predators and exploitation. House Bill 207 adds definitions of child sex doll, computer-generated image. House Bill 207 makes it illegal to possess, traffic, import, or promote a child sex doll, and goes on to include offenses where it involves computer-generated images that uses an actual minor or minors as the source, as we just saw in what Chair Westerfield showed us with AI and the dark web. This bill has the support of our Attorney General, the Kentucky State Police, the Kentucky Sheriff's Association, and the Kentucky Association of Chiefs of Police, and several victim advocate groups. House Bill 207 closes a loophole that has allowed pedophiles to practice victimization of children. This bill will save countless children from rape, sexual abuse, and trafficking. And I'll turn this over to my witnesses.
Good morning, members of the community. On behalf of Attorney General Russell Coleman, thank you for the opportunity to speak today. I'm going to talk about the child sex doll portion. Years ago, I used to sit in Lieutenant Bowling's seat, was the ICAC task force commander. We intercepted a number of these dolls. Just want to say that when you come across one of these child sex dolls, there is no doubt why it was created and what it's used for. And we're appreciative of the language that does close the current loophole and will allow us to charge the offenders that are using these dolls. We also believe that this bill provides law enforcement and prosecutors tools to combat a newer trend in child sex abuse material, and that is the AI portion that Senator Westerfield just shared with you. And I will turn it over to Lieutenant Bowling to talk about that.
Thank you, sir. Just like Mr. Chairman explained, AI is here, and I have found that AI is phenomenal for middle school algebra because I use it all the time for that. And we use it in our schools to get ideas for thesis papers and research papers. But like any phone application or any tool that we use for good, there are going to be those that seek it out for bad. And talking about nudifying or to nudify an image, since I testified in the House Judiciary, we have a very famous case nationally after the Super Bowl involving a very famous singer. They had her pictures spread across the nation in a matter of seconds, if not minutes. A simple AI prompt, and her pictures are everywhere. And that's the thing with these applications, with these websites, these AI-generated websites. You can take a known picture, and for example, it could be a classmate in school, a clothed, clean, normal picture, as we would call normal. Load it into this AI program, and the AI program will tell you what this person will look like nude and generate an image for you to save or do whatever you want to with it. So I think about my kids that are in high school, middle school, and college. What if a picture of one of my kids was posted somewhere, shared around, because that happens. The main thing we want to do is to save victimization. We want to save the psychological impact it will have on our school kids with cyberbullying, with these images being passed around, and obviously empower these individuals and say that, Kentucky, this is a deterrent. We're not going to stand for it. We're on the edge of technology, and we're doing everything we can to fight those that want to offend using it. But thank you very much for your time.
Got a motion from Senator Schickel and a second from Senator Wheeler on the bill as amended by the sub. Members, any questions? Senator Byrd.
I'm sorry to always have questions. The AI part of this bill, I don't have any questions about, but I was completely unfamiliar with child sex dolls, so I had, of course, to Google it last night. Was a little scared to put it in my search engine, but I did, and apparently there is research on the subject. Not much, but there are what they call MAPs, minor attracted persons. And the limited amount of research that's done on these dolls, guys, suggests that they actually, for people who are attracted to minors, that these dolls actually decrease their proclivity to go out and attack children, that it actually gives them a release that makes them less likely to go outside of their home. And what was interesting is the research did not support the same conclusions for people who were adult attracted using dolls. That did not diminish their proclivity to engage other people, but for those with the, so I'm just a little concerned that, and like I say, the research is not very good. It is not comprehensive, but the research that is out there is conclusive, equivocally conclusive.
I actually disagree, and I'll let Representative Deeds
Okay,
respond
thank
if
you.
she'd like. We've got expert testimony who shared testimony by letter with this committee several years ago when I filed the bill, and gave an updated letter to the representative in support of her bill, which says the exact opposite. You want to respond?
Yes, thank you. Thank you for the question. In your packets, I'm not sure if it made its way in there, is a letter from Dr. Connor that says something completely different. So Dr. Connor's very well respected, at least in northern Kentucky, I think across the state, and he provides the assessments for sexual offenders and reports back to the court. So for him to provide this letter, and what he says it is actually, it's an escalation in behavior if you're using a child sex doll. And what we're really trying to do with the child sex doll, and what we found is that our law enforcement needs something. So if there's a child sex doll, that didn't give them probable cause to get in the door to look at the phone or look at the computer or look at the pictures. This is going to give them a tool to get to the next step that they need in order to protect our children. But Dr. Connor's letter should be in there, and it's updated from 2024, and I talked to him before having
I
him
don't think
submit
it is
the
in
letter.
members' folders, but I'll make sure it's distributed today.
Okay, thank you.
Because we have the updated letter. Thank you. Any other questions? Seeing none, Mr. Secretary, please call the roll.
Senator Berg. Aye. Senator Carroll.
Aye.
Senator Deneen. Aye. Senator Neal. Senator Schickel. Aye. Senator Stivers. Senator Storm. Aye. Senator Turner. Aye. Senator Wheeler.
Aye.
Chair Westerfield.
Aye. Bill passes with favorable expression unanimously at 9-0. Thank you, Representative. Thank you, gentlemen, for being here. I appreciate the work you do. It's hard and difficult work, but it's important work, so I'm thankful. All right. Seeing nothing else, anybody else have anything else before we adjourn? Motion to adjourn accepted. We are adjourned.